All right, shall we start? Good morning, everyone. Welcome to this panel discussion on private enforcement. I will first introduce you the members of this panel, starting on the far right. Malcolm from Metro AG, so the well-known wholesaler. Malcolm is the head of competition and compliance at Metro AG. He has I think a very broad experience when I see his resume, because you've been on many fronts, working for the Bundeskartellamt, so the German competition authority, for the Federal Office of Justice, then also being a competition lawyer at a well-known German law firm, Hengeler Müller, before joining Metro AG. So you've seen, I think, competition law from different angles, which is, I think, very valuable for our discussion today. And next to Malcolm, you have Danny Verzelen from ECS, European Containers, from Belgium. Danny is from the transport and logistics industry. And you have a legal background. You're currently the legal manager at ECS. You've been there for 29 years? 29 years. So this is what I call long-term commitment. And you have seen quite a bit of what is transport, because you are specialized in transport and maritime law. You were also in the Navy after your studies, before joining the community of Bruges, but also now ECS. So except air transport, you've seen it all. Railroads, more or less. Yep. So if you have any question about transport, you can ask Danny. And then next to me, Giacomo Lorenzo. Giacomo is leading our Italian activities in all fields of funding. And you joined us from a well-known law firm in Italy, Gianni Rigoni. You were there a lawyer in their dispute and arbitration department. But I must say, I've known Giacomo for now 4 years, close to 4 years. And he's quite versatile, because when we first met, it was about arbitration, but now I see that has become a true expert in competition litigation, having talked to many Italian groups involved in competition law claims we are funding in Italy. My name is Charles Demoulin. I am the Chief Investment Officer at DEMINOR. We are a litigation funder with offices a bit everywhere in Europe, but also in the US and in Hong Kong. As part of our funding activities, we also finance competition law claims, mostly in Europe, including Italy. And today, so many thanks again to Paolo for his kind invitation. It's the third consecutive year we are here in Rome. It's always a pleasure to be here, always a pleasure to share insights with all of you and also to learn from you. And today what we wanted to do was to focus really on the practical parts of private competition law. We are close to 10 years after the adoption of the Private Damages Directive. Most of you have seen there's been a lot of activity on the litigation front. And I remember a few years ago, people were saying, well, private litigation in competition law, that's mainly 3 countries, the UK, the Netherlands, and Germany. But we've seen a lot happening outside of these markets. And I think to some extent that this is also being helped by the case law from the European Court of Justice. Law firms have had to adapt, because now you see the competition law departments, it's no longer public enforcement, but it's also private enforcement, where they need to team up with their litigation department. We see boutique law firms being created with a clear focus, that's more on the plaintiff side, on private litigation. Economic experts used to advise big corporations, mainly targeted by investigations from the competition authorities, but now they also need to spend, I think, a huge amount of time advising groups involved in private litigation on both sides, plaintiffs and defendants. We as funders have been asked to fund more and more of these litigations everywhere, not only in the countries I mentioned before, but also in Italy, Spain, in other markets. But I think today we would really like to give the word to those who are at the core of competition policy, the business. So if there is an infringement, who are the victims? What do they think? What is for them the key objective, and what are the key parameters when they are, well, invited to join the litigation, or where they consider starting their own litigation? So this is why today it's the views from the inside, from the business. And Malcolm, if I can start with you, could you share your perspective? So when you look at what has happened in the field of antitrust private enforcement in Europe, what have you seen over the last years? I guess you have seen evolution, but what type of evolution? Do you receive more and more proposals to join these collective actions in Europe?
Yeah, thanks. Firstly, for all the kind words at the beginning. I hope I can live up to them, and thanks for having us. It's really a great pleasure.
Mike is, I think, not.
Is it not?
I think it is on.
I'm just. Yeah. All right. Thanks. So again, a great pleasure to be here, and thanks everybody for listening to us and for hosting this. Yeah, I think, as you alluded to, it's been quite a development, probably over the last decades. And we as Metro AG, which is, if you don't know it so well, a global wholesaler, we buy and sell food and non-food products at quite a large scale, which means, if there's a cartel in that area, we're obviously very, very much affected, and can be in worldwide. So we're looking at these cases very closely, and have been doing so for decades now. And I think clearly the attention of the law firms, of funders, of companies such as ours is much higher nowadays than it had been in the past. And it's also much more probably professional than it used to be. We have a whole lot of experience. We're set up to deal with these cases quite routinely, and it's a large part of our competition law department's job to pursue these claims, which I think makes it very interesting, and you can see also through the developments in the legislative and the decisions by the courts across, maybe in Germany, I know it's slightly better, European level, but across the board, that there is a doability to these kinds of claims, and that's why I think it's become attractive also for funding purposes. So yeah, we do regularly, particularly in follow-on cases, we do receive contacts whether a claim would be interesting, and we look at each one very carefully. We are set up in a way that allows us to pursue them without funding even, so that is a decision that we also take. Do we fund it ourselves and take the risk, or do we look for funding? We have our own economist. We have colleagues who are very much aware of how to prepare the data and to collate it in a way that allows for the evidence should it come to that. Yeah, I think that sums it up.
And you, Danny, from your perspective, do you?
First of all, Malcolm, Charles, I thank you for the nice words. From our perspective, we came in contact with litigation funding with the truck cartel case. To put you in the picture, the European Commission convicted and fined 6 major manufacturers of trucks for a record fine of 3 billion euros between 1997 and 2011. We, as a transport company, bought 650 trucks. So they were convicted for price fixing. The 650 trucks we bought, there is a price which was calculated, and I've been very careful, between 1,000 and 10,000 euros too high. So you can easily calculate 650 trucks. And that was in fact the first time we as a company, because we are a transport and haulage company, we came in contact with litigation funding. This was important for us. Going back to the landscape in Europe, I think there are 2 major features which changed the landscape in Europe. First of all, we have the legislation. The EU Directive 2014 changed a lot because a lot of EU members implemented those rules in national law, also in Belgium. You know, in Belgium we're very famous for the beers and the chocolates, but when it comes to legislation, we are a bit conservative. I see nowadays a trend in Belgium that legislation is more open in Belgium. There is a good, let us say, approach towards the courts. Another part which is important, I think, is the litigation funding, is created a level playing field, especially for the small businesses. It makes the approach to start with litigation funding more easier, because if you have, as a small business, stand up against a big companies, it's not always easy. So the financial risk and the size of the claim also plays a very important role.
Thank you. Giacomo, from your views from Italy, you talk on a regular basis with Italian businesses. What do you see happening in the Italian market?
Thank you, Charles, and thanks also to the LER Competition Festival organizer for having us for the 3rd year. So from the Italian perspective, I believe that the situation has changed a lot, especially in the recent year. As Danny said before, one of the factors was, of course, the implementation of the European directive with the decree number 3 of 2017, because this implementation has streamlined the private enforcement action process when it comes to burden of proof, legal standing, and also quantification of damages. So the legal framework now is more clear. And also now in Italy we have only 3 specialized courts that have jurisdiction over this type of claims, and so this could lead to a better quality in the decision. Apart from that, I think that in Italy there was a huge change 4 years ago when the litigation funder entered into the market. And because when a litigation funder start investing in a case, they spend a lot of time and a lot also of resources in create awareness about the case. So what we try to do is to organize conferences, organize meeting with the potential victims. And this is crucial, because if they don't know that they are entitled to damages, they will never start the litigation. So I think that this awareness led to an increase in the number of private enforcement action. And as Danny said before, I think that another thing is that these private enforcement action are very complex and very costly. So sometimes the main obstacle is that the company doesn't want to invest their money to hire specialized lawyers, specialized economists. And so the fact that they can rely on a business partner, a litigation funder, probably I will not say that eliminated the obstacle, but is an incentive to start the private enforcement action. So we are assisting an increasing number. I checked some statistics, and from 1990 to 2010, there were more or less 150 private enforcement action. I think that in the last 3 years, 4 years, we had the same amount of action, probably more. So, and I think that the main two factors are the new legal framework and definitely the advent of litigation funding in Italy.
Sure.
For the truck cartel case, we started with DEMINOR for the litigation funding. Why did we start with DEMINOR? First of all, we didn't have a lot of experience in that area. We were approached by several companies, but the personal touch, the personal approach from DEMINOR was very important for us. And that was the key factor to start with them. I mean, to feel safe and confident if you start with such a group's claim, if I may call it so, is very important. And also, very important is the regular update, because the truck cartel case is now before the courts in Amsterdam, in Holland. And you must reckon that for us, that's a new world. Also important is to inform regularly the stakeholders, because they want to know what is happening. And therefore, the regular update of DEMINOR is very important.
Well, I would like you to keep the microphone, because you just started this discussion on something which we would really like to know more, and probably most people here. When you are being presented with the opportunity, you say, okay, there's been a cartel. It's been sanctioned by the Commission. Someone comes knocking on your door and say, you know what, it could be a lawyer. It doesn't have to be a funder. It could be a funder, it could be a lawyer, it could be even economic experts. What will be the criteria that you consider to be relevant to say, okay, I want to take that opportunity and claim damages? What are so in your own decision-making process with your management, what are the main criteria that will be decisive, whether to help you decide whether to join or not to litigate? Yeah.
Well, first of all, an important aspect is the size of the claim. I think as a company... It's working? Okay. The size of the claim is a very important aspect. You have to consider that once you decide to go further, and if you start with a lawyer or with litigation funding, you lose a bit of control. That's like that. You have made an agreement, you lose a portion of control over the claim. And also another important aspect to start is, like in our case, we had to go back to 97. So we had to present invoices from 97 to 2011, which is not evident. I mean, you have to go very far back. In Belgium, regulation is 7 years to keep invoices, etc. But we had to go back 20 years. So from that perspective, the effort you have to make to gather all documentation is very important, because that is what you have to present. And finally, if you go to court, I had 2 employees working full-time a whole week to gather all the information. On top of that, if you go further in the legal proceedings, there was another aspect that was came forward from the opposing party, was the fact that they said, yes, probably you have paid too much for those trucks, but we sold in the meantime a lot of those trucks second-hand. So this means that you also got a better price on the second-hand market. So also there, in the final calculation of the claim, is something you have to present. So our main obstacle was, of course, the size. Are we going to go ahead with litigation funding? And secondly, to present all the documentation.
So I mean, financial incentive, is it worth it? Yeah. And then the practical obstacle, okay.
Can be a barrier to start with.
Okay. Malcolm, how about you?
Sure.
So yeah, I think you've touched on quite a few aspects there. I would just add the commercial relationship is very important for us as well, because these are suppliers who we deal with regularly. So, and our business is not competition law litigation. We make our money through commercial business, and that means we need to keep the commercial relationship, if it's very, very important for us, to keep it aside from our litigation efforts. That's very important. So I don't want to say that as the primary aspect. We always need to make sure that our commercial colleagues are entirely on board with what we're doing. Now then, the other aspects, of course, yeah, the claim is obviously more attractive if it's a larger claim. But I think there's also opportunities for smaller claims, and I suppose claim value is relative to the size of the business also. Group actions might be more attractive, or solutions where you can share costs, because obviously in these claims are very expensive as compared to other types of litigation, just because you have the economic analysis. As you said as well, we have a lot of internal resources that are bound by these kinds of actions to get the data, and to get the data into shape which is ready for litigation. And of course, we're always looking out to settle with defendants, obviously on favorable terms, on acceptable terms. But to the first point I made, in order to make sure that the commercial relationship is functional, settlement is a very attractive way of reducing costs and keeping the relationship.
Okay, thank you.
Can I add one thing?
Sure.
Another aspect is the length of the proceedings, the duration. I mean, in our case, I had to convince the stakeholders to start with that, because the first reaction I always remember was, yeah, but can we settle, yeah, before we go to court or whatever, with the manufacturers themselves, out of court. This is still possible, of course. Mm-hmm. And you have to convince the stakeholders, yeah, how long would that last? I mean, are we talking about a couple of months? I said, no, we're not talking about a couple of months. It will take probably some years. So that's also an aspect which is important, maybe more in small and medium companies than in very big companies. How much do you have need of liquidity, of cash? So, I mean, that's also something you have to recognize.
Okay, but we'll come back to this more financial dimension later on. Giacomo, what do you see what are the questions that Italian companies are asking you when you tell them, look, it could be an interesting case for you?
Yes, unfortunately the questions are pretty much the same that what they just raised. So the first question is, how can if I want to start a litigation, but of course on the other side I have a commercial partner. So I'm afraid that if I start litigation against them, I will jeopardize our commercial relationship that can have a direct impact on my business, especially when we are talking with the small, medium-sized companies. Because when we are talking with larger corporations, probably they have more contractual powers, so they are less afraid of starting a litigation in certain cases. So this is the first point. And the question that they ask, do you have a solution for that? And the answer, unfortunately, is that there is no solution, because if you want to start a litigation, there will always be the risk to jeopardize the relationship. However, in my opinion, usually litigation funders, what they do is bundle, and what we do as well, we bundle the claim in the same proceedings. And so being in a group probably can be dilute your position, and so this could have, less impact on your commercial relationship, and even have a stronger position here from contractual side, because of course the cartelists could not have repercussion. Everyone cannot interrupt their business relationship with all the members of the group. So this is pretty much the first question. The second question is, okay, how much money I can get from the litigation and how long it will take. So what just you said, And regarding the first question, what we do usually, we do a preliminary analysis with our economist in order to understand what was the overcharge and what are the amount of the damages that they could potentially recover from the litigation. And so in collaborating with us, they have a clear view on how much money they can get out of the litigation. Regarding the second question is a tough one because, as you may know, in Italy, the proceedings could last several years. You can spend 2, 3, 4 years in the first instance and the other 3 years before the Court of Appeal. So you need to be ready to wait 7, 8 years. Of course, there is the possibility to enter into settlement discussion, but it is something that we don't know at the beginning of the litigation. Another option, but probably we will touch it later, is the possibility to monetize the claim. And this is very interesting for the companies because among our services, we can also offer to buy the claim. Of course, there will be a huge discount, but the advantage is that you don't have to wait several years. You can immediately monetize the claim, so it's pure cash flow for your company. And you get rid of the litigation. So that's the main advantage. And the last probably problem is collecting the documents, because I've been working on the Carughieri Carbo Cartel case in the last 3 years. And you know, when we ask to the clients, look, we need the invoices from 2005, 2006, they say, okay, but first of all, I'm not obliged to keep this document. I don't have them anymore, or I need to spend several weeks in order to recover it. So in this case, we can always help because sometimes we employ one of our colleagues that can help the clients in getting the documents, analyzing the documents. So I will say that now that I was listening to Danny and Malcolm, I heard pretty much the same word that I've been hearing for the last 3 years, I would say.
Okay. And it's interesting because it's very often we see people commenting on the decision, saying it's the case law, it's the regulation, it's the purely legal matters. But hearing you, it looks like for you it's not that problematic. It's rather concretely. It's actually you're bringing us back to the more concrete aspects of the business, which is, well, you know, it's about documenting the purchases. But is it fair to say, Giacomo, now can we say that on the legals? I mean, we will have this afternoon a discussion on the quantification, but apart from the quantification, would you say now, well, the purely legal part of this kind of claims is more or less settled in Europe, more or less, and that the remaining challenge is purely a practical one in addition to the quantification? Would you say that?
Yeah, to be honest, in the discussion with our clients, they always ask an introduction to the case. So what was the decision of the competition authority, you know, who they, you know, what are the potential defendant, but more practical aspect. They never go into the details of the legal aspect of the anti-competitive behavior, for example. Probably because they now have the possibility to study before have a conversation with us, because also what I said before, there are several articles that you can easily find on Google or another, so that explain very well what happened. And by the way, also the decision of the authority is public, so I think that they do their homework before approaching us.
Anything you want to add to this?
Well, I mean, I think it builds on the legal framework. So we're obviously always looking for improvements which make it less resource intensive, less time consuming, less delayed to claim for these types of damages. And you know, the legislative and the judgments are, you know, drivers of that. So I would say it's well connected. The other aspect, of course, is damage quantification and what kind of burden of proof, what we need to show, the evidence burden that lies very heavily still with the claimant. I mean, you hear our gripes about weeks or potentially months, maybe years of finding the right evidence, and then having to do very time-consuming economic analysis of that evidence, and then still not knowing exactly what the outcome will be, because obviously the defendants also have their very costly advisors who do the same calculation and come to a completely other result, and then leaving the judge, if we don't settle, to determine what the damages would be. So I think there, obviously, there's room for improvement also in the legislative. So to your comment, is it settled? I kind of hope not.
Okay. But then is there now a call to the courts and the judges to say, it's up to you now to try to manage the litigation in the most efficient way? Would you say that's where a lot can still be done in the way courts are handling these kinds of disputes?
With regard to that, I refer to the Belgian courts and the Belgian legislation being very pragmatic and formalistic, the courts in Belgium. So also there is an evolution in Belgian legislation that they are more assertive and more accepting and willing, and a very important role there is for the experts. They are more and more relying on experts, economic experts, whatever, to quantify the claim, or to quantify the amount. And that's a very important aspect in Belgian legislation, and we've seen that evolution very hard. I remember a case going back 2008, was a case with Herbo, the elevators, a very big case, finalized this year, started in 2008. So also there, I think very problematic was, first of all, in first instance, the approach of the Belgian courts, because you had to prove the causal link, which is sometimes very difficult. Then they went into appeal to the High Court, and then finally there was a decision made in 2024. So there, of course, if you are a claimant and you have to wait 16 years for an outcome, I think if we have to wait with the truck cartel for 16 years, I don't think I can sell that to our stakeholders and to the owners of the company.
And I'm not so sure that funders would fund a litigation that is going to last 16 years either, so we agree on that. Now, turning to, and you hinted at this, Giacomo, for all three of you, because funding, finance, I mean, there are different ways of funding litigation. It's purely paying the costs of the lawyers, the economic experts. It can also sometimes be covering the risk of others party, which is relevant. I think in Germany, it's not to be underestimated, like in the UK. Then you have the issue of monetization, which is transforming funding into, it's not only the costs, but it's also monetizing the value, so realizing the value of a claim, because very often companies, they tend to see that more now than before, that it's an asset. For them, it's litigation. Usually I would assume your CFOs will say, guys, litigation means more costs. Do you see now claims as a contingent asset with a value attached to it? And would you consider, well, why shouldn't I monetize part of it or monetize the entire asset because I want to raise cash? So two sub-questions. Would you consider the various options, and what would be the relevant parameters for you to say, well, I would rather monetize, or no, I want to keep my asset, but only fund, have the costs being funded?
Yeah, so, I mean, it's an interesting question. Maybe I'd frame it slightly differently, because we are, in a sense, victim of an illegal agreement between parties who have damaged our company in these cases. So it's a bit hard to say we're monetizing an asset, rather we're trying to recover a harm that occurred. So that's how I would look at it. We also have the duty to recover these harms. We are a publicly traded company, and if we see the opportunity to do so, we're obliged to do so in order to protect our company and its shareholders. So we always do pursue these claims if there's merit to them, and if the benefits outweigh the costs. And then the choice of model, I would say, is very dependent on the jurisdiction, on the size of claim, the type of commercial relationship we have, and can vary quite a bit. I think what we would do is make sure that it's procedurally secure in the jurisdiction that we pursue the claim. So we wouldn't want to spend a lot of time in the courts arguing on procedural questions, whether the model that was chosen is actually legal in that jurisdiction. That's obviously a worry. But if it were a claim which is particularly, well, let's say smaller claim, then perhaps more of a group scenario is attractive. That would be a commercial idea. I don't think we have a scenario where we would say this is an asset that we just want to sell off. I don't think that's how we would view it, just because we have quite professionalized this analysis of whether we have a claim, whether we think it has merit, whether we think we can win in court, and at that point we're pretty sure that we can pursue it, and we wouldn't want to sell it under value to somebody in that sense.
Thank you. Danny, what about you?
Well, important for us, for me, was what is the financial position of the company? Do we need your money? Do you need cash? Do you need liquidity? Obviously, if that's not the case, and we chose for our truck cartel case for the standard litigation funding, if you choose to purchase in part or in whole your claim, of course, then you have to reckon that the buyer obviously will examine the total frame of the claim, and that the recovery will be probably less than that you would recover if you go to court and take proceedings. So for us, the important aspect and remains for our stakeholders was, first of all, the size of the claim, the possible amount of recovery, and also come back to the same, the duration. That was very important for us. I think that is main features for us as a company for litigation funding. Okay. Because also another aspect is assignment, but if you assign, then you transfer the rights of the claim, and then you have to reckon that you are not longer the assigner, the assignee. So it's another approach from a legal point of view. Mm-hmm. So again, for us, standard litigation funding was the most suitable. Okay.
Before I give the word to Giacomo to have the views on the Italian market, I just want to follow up on something you said that I believe personally is key. You said it's our duty towards our shareholders to at least consider litigation, because this is, I remember we started our funding business rather in the financial markets with investors. So our clients were very large, still are, pension funds, asset managers. And I remember that initially when we were saying there's been a fraud, there's been misrepresentations, stock price went down, we went to see pension funds and asset managers, and we were saying, there is money to be recovered. And you had two classes. You had the ones, probably more the Anglo-Saxons, saying, yeah, we're going to do it because it's our fiduciary duty. I mean, we have our own investors. We have the opportunity to claim. It doesn't cost us anything because of funding or because lawyers in the US would work on contingency fee basis. So they felt compelled to to take action, saying, if I don't do this, I leave money on the table, and this is money that is actually belonging to my own investors. And then you had in Europe maybe more conservative players saying, I don't see why, I don't want to be involved in litigation. But that changed dramatically over the last 10, 15 years, because now we see all institutional investors from any country saying it is our fiduciary duty. And I find it extremely interesting that you say it yourself, but from the business side, saying towards my own shareholders, stakeholders, I consider it, whether it's using funding or not, but saying, if I have an opportunity to recoup losses, I need to consider it. What you're referring to me, is an extremely important change in mentalities in the business world. But now, Italy, what do you see? Is there more appetite in Italy to monetize, or is it like Danny and Malcolm have said, they want to keep most of the upside of the litigation?
Yeah, in my personal experience, the companies are more interested in a litigation funding solution. And that's because they can keep a sort of control over the case. And of course, as I said before, on the other side, there is a commercial partner. So they keep a sort of control over the case. And also they can, start the litigation without spending any money and still have the majority of the compensation when the case will be settled, on where there will be a decision, final decision by the court. However, I predict that in the future this could change because I think that some companies are thinking about litigation as, a legal asset, first of all, that can use to monetize, to have, cash flow, but also it's expensive, not just in terms of money, but in terms of time. Because even if someone else is handling the case, you need still to report to the stakeholders, you still need to receive the update, talk to the lawyers. So the fact that you can monetize and get rid of the litigation is extremely interesting for the company. And there are, just to, to complete this part, there is also the possibility to assign without a compensation. But this has been used by litigation funders just to bundle the claim. It's another way to bundle the claim, and there were 4 important decisions by the Supreme Court in Italy that said that this is allowed, the contract is valid, probably the only and first decision on this type of agreements. And this is, in my opinion, a huge development. So in the future, we will see more and more the assignment model and also the assignment model with the compensation, so monetization.
Thank you. I know there's a question, if you don't mind, if we can conclude, and then, sure, there is time for questions. So wrapping up, all 3 of you, would you say these private damages actions are definitely something positive, and it's good for your business, but it's also good for the market in general? So do you think it's positive? But you may say it's positive provided that, so it's not binary. If you want to answer in a non-binary way, please do so. Then I think I heard, maybe if you can also confirm whether you agree with Malcolm, whether it's part of your duty as in-house counsel to say, if there's an opportunity, I need to present it to my management. And then finally, question is, looking to the future, do you think it's going to grow? There are going to be more of these cases? And do you think, in your opinion, as a business, that funding will play a part in the growth of this type of claim? So is it good? Yes, but yes, provided that, or no? Is it something that you consider as a duty, and how do you see the future? Malcolm?
Yeah, sure. I'll try and wrap that all up in a bow. So yeah, of course we see it as a positive to be able to recover damages in such cases, because they are damages which can go into the millions of euros, and I think the ability to have your claim funded is actually helping us when we, as we just said, see it as our duty to pursue these claims, and we speak and report to management on the ability and the opportunities we see there, that we can also say it is a non-risk scenario in that sense, as we are able to receive funding, which reduces the risk of a costly and time-consuming and resource-intensive exercise. So that's, I think, a very positive thing that has developed. But I would say the outlook is still leaves us a bit wanting. We still see court cases taking a very long time. I hear in Italy they're looking at specialized courts or have specialized courts, but in other jurisdictions that's not the case. That could be quite interesting, that we actually have judges who are well acquainted with these quite complex cases that are able to deal with them more time efficiently, because at the end also the funders have the same questions, right, as you alluded to as well. If this is going to take 10 years, how attractive is it? What is our return? So that needs to be improved, and I think if that's not going to happen on a national level, it could be on a European level that needs to be pushed forward as has been in the past. I think the Damages Directive was a very, very helpful tool in that sense. I don't know, were those all your questions, or that was the outlook? Yeah.
It's a good wrap-up comment.
Thanks.
Thank you. Danny.
Yes, as a legal in-house counsel, I think it's always important to safeguard your company. So to bring in the picture the possible financial losses or the possible financial risks. So you always have to safeguard, and you have to be open to your stakeholders, to the owners of the company, if a financial risk is at stake, to start the discussions and listen, these are the opportunities. What are we going to do? Are we willing, viewing obviously the size of the claim, are we willing to recover? Do we make the effort? What options do we have? Do we via a private or outsource it to a legal counsel, or go we via litigation funding? There's something you have to consider. So I think that is always the object, and I think Malcolm will support that you always have to safeguard it. Another aspect is, a question from Charles, is private damages, litigation funding. Is that interesting for both small and big companies? I would say yes. Yes, it is interesting for both. For the large companies, I think it's very important that they can serve as a strategic tool to recover significant financial losses. For the small companies, it's an opening because they are supported and they know they are most of the times against big opponents with big financial resources. So for them, it's a mean that without taking too big financial risks, try to recover.
Yeah, I think that the last 2 points that Danny mentioned are very important, because we should make a distinction. Honestly, we were more successful with large corporations because they are interested in optimizing the cost of the litigation. And so if they can outsource this cost, for them is better, because they use this capital for their core business and their activities. But for the medium and small size companies, it's also interesting because sometimes they do not have, first of all, the financial means to pursue the litigation, but also the knowledge. They don't know who are the most experienced lawyers or economists to bring the litigation. So litigation funding could be a tool to level the playing field and also to guarantee the access to justice sometimes, so in the private enforcement field. So looking at the future, I think that in Italy we will see more private enforcement litigation, that's for sure, and also more litigation funding funders active in the let's say in this country. Probably we should take a look at more advanced jurisdiction. I'm thinking, for example, about UK, Germany, the Netherlands, where they are of course, in advantage stage when it comes to private enforcement and litigation funding. I think that probably 80–90% of the private enforcement litigation are backed by funders in the UK, and this could be the same in Germany. So we are a little bit behind in Italy, but hopefully we will go there as well.
Thank you. Quick question. Sure.
Okay. Hello, my name is Balin Bassola. Together with my colleague, we have been representing claimants in big private litigation claims. In the past years, there have been cases which made the life of litigation funders perhaps easier in Germany. And now we see the opinion of AG Spunar, which is also relevant in this case. Do you still see any hurdles or any barriers in penetrating certain jurisdictions regarding litigation funding in continental Europe?
So what would be if, so it's kind of TripAdvisor, where would you litigate and where would you not litigate, if I can summarize? Are there any countries where you say, or is it pan-European?
My question would rather be whether you see any barriers to entry to certain jurisdictions regarding litigation funding.
Okay.
Sounds like a question for Giacomo.
So the fact that I'm working in Italy is definitely another step in litigation funding, because there are a lot of opportunities in the Italian market, but litigation funder arrived later compared to other jurisdictions. And this is because probably they were skeptical about the Italian market, they were skeptical about length of the proceedings, and now probably some of these doubts have been surpassed, or we are conscious about what's the timing, so this will be reflected in our financial model and we start from there. Answering your question, of course, I think that there are some jurisdictions where probably will not work because we are not comfortable with the judicial system. This is the starting point. We don't know how does it work there, and so the way to solve this problem is having a local counsel or a local colleagues that can explain you how does it work. And of course, another thing to take in consideration is the amount of data that are available. For example, in Italy, in my opinion, we have a lot of data, and especially now there are a lot of judgment available, and so this give you some comfort. Because, of course, if you have some statistics on how many private enforcement litigation, handed in with an outcome, a positive outcome for the plaintiff, of course, you are more comfortable. But answering your question, there are several, I think, countries where we are not present, different countries where we are present, and probably will not work there. But, Charles, probably you have, not yet at least.
But I think hearing you again, it's really about, I think, the experience of the judiciary, and the more experienced the courts, and also the tools they have to make it efficient, I think the better. Whether it's a good claim or a bad claim, because if people are bringing frivolous claims, again, I've heard it many times, funders are going to facilitate frivolous claims. My answer is very simple. I am not Bill Gates. I don't have money to throw through the window just for the fun of funding lawyers and experts to bring frivolous claims and lose all my money. So that's, but it's more, I think if the courts could have also the means and the resources, probably that's more a comment to all ministries of justice in European Union to say, invest enough money in your judiciary so that they have the resources to hire maybe more judges, more experienced judges, because it's, I would say we have a great car. I'm not a big fan of Formula One, but I mean, it's like we have a great car, we have great mechanics, we have a great circuit. We need a tremendous pilot. And the directive helps. Businesses are willing to take actions. Funders are available. You have, so the lawyers, you have the economic experts, but it's a group effort. and we need courts that are able to assist all the parties. So to me, it's rather a matter of practice, and I'm not so sure that a law would change that. A directive will not make it happen. So I think it's a policy issue, actually. It's a policy issue to be dealt with by the governments, so that there are courts. And I think Italy, by saying we will have dedicated courts in Italy, in Milan, Naples, and Rome to deal with that. You have the CAT in the UK. I think that's an interesting example to say we will have a dedicated court in the UK. Maybe that's an example to be followed in other countries in Europe. Sure.
Thank you. Thanks for the interesting session. It's really appreciated. It's so kind of interactive and dynamic. Another question for Giacomo, I think, unfortunately. So just for context, I work at Hausfeld in London, so we do a lot of private damages litigation, funded, most of it. My question was more kind of focusing on the Italian market. From the funder's perspective, what do you see are the biggest procedural obstacles, and also whether there is a bit of forum shopping, between the three different tribunals, Rome, Naples, and Milan? I know that obviously the choice, as to in which tribunal to start the claim also depends on where your clients are, but I wondered if there's a difference between the three, if you see kind of, more claimant-friendly judgments coming out of one of the three. So yeah, just two questions, I guess.
Okay. If I understood, the first question was more about the obstacle for the litigation funder entering into the market.
Yeah, entering into the market, but also when you kind of prepare your budgets, for example, where are the procedural uncertainties, in the Italian systems? What do you need to watch out for?
Yeah. No, first of all, I have to say that litigation funding is still a relatively new concept for a lot of people, a lot of lawyers, a lot of practitioners. So the first barrier that we have to surpass is to make the people aware about the solution that we can offer. This was probably the first step. Regarding procedure, of course, litigation funding is not regulated in Italy. So there were a lot of discussion of what type of contract. Is it, sometimes they said, is an insurance contract? Of course not, it's a loan. Is a financial activity, is not a financial activity, because all these questions are different consequences. And there is still a lot of discussion, but the decision of the Supreme Court solved some of these probably questions and problems. This is, in my opinion, the first barrier. The second part is that you need to be aware that you are going in a country where the length of the proceedings is an issue. But on the other hand, we are aware about this problem, and I think that also the legislator is trying to do something in order to solve this problem. Now that we had a recent reform, and we still have to see what are the effects of this reform regarding the proceedings, but I think that be aware about the problem and try to solve it is already something. So for a litigation funder, of course, when they can get the return on their investment is important, and if you want to work in Italy, this is probably another thing that you bear in mind. Regarding the forum shopping issues, I don't see it as a problem, because, as you said, it depends on where the defendant were located. Of course, what we are doing, and I think other funders are doing the same, we are bundling the cases, and we have to select which court we will, we will like. My personal experience, I was working as a lawyer before, and I'm more comfortable, for example, with the Court of Milan, just because I think that they have more pragmatic approach. But on the other hand, I am also conscious that the Court of Milan is overwhelmed. They have a lot of cases, so this could impact on the length of the proceedings. But in my opinion, to see, I'm optimistic, and I think that this will change also thanks to the litigation funder. Why? Because we are bundling the plaintiff. So instead of having 200, 300, 1,000 of individual proceedings, the judge will handle one proceedings with more plaintiff. So this, in my opinion, will have a positive also impact on the judicial system and will also help the judges because they have to manage one single proceedings. I don't know if I answered your question or if you have. Okay, thank you.
So, Alan Riley, College of Europe. My question is very simple. What is the one thing litigation funders would like the European Union to legislate to make your life easier? And what would that be?
It's too early for Christmas. Well, as you know, there is a discussion going on. Well, discussion. There was an initiative from the European Parliament on trying to regulate litigation funding. I would say, I don't think funders are generally against any form of regulation. We like smart regulation. So I'm a bit concerned by the initiatives now being presented to the Parliament because it looks like it's rather trying to make it much more difficult for funders to fund litigation. And we saw it in Germany when the collective action directive was implemented in Germany. At the very last moment, suddenly there was an amendment saying, okay, if there is funding, the funder cannot get more than 10% of the damages awarded. If they wanted to kill the ability for funders to fund, then they did it. And that's what we said. Stupid. Why 10%? So rather than saying, what should Europe do to make it easier, I would just say, well, please don't do anything stupid that would make it impossible for funders to play their role. Okay, I think it's okay to have judges in the context of collective actions opt out for consumers. To me, it's okay to have judges playing a certain role, like the judges do in the UK with the CAT, looking at is it fundable, is the agreement in the interest also of the entire class. So my question would be just, it's not what should you do, it's just what you shouldn't do is going too far. But it is not in our interest. I think transparency is good. Auditing, I mean, that funders should be audited, yes. I mean, we have our accounts are audited. We have the offices are in the EU member state. We're not funding via exotic places. I think it's transparent for people. Self-regulation, why not? We have now the ELFA, the European Litigation Funders Association. We were one of the founding members of the association. I think self-regulation could play a role. Why not? It is in our interest that people have trust in what we do. But what's now being considered at some level is rather protectionism that would destroy it. So I'm not looking for anything special, like give me all latitude to do whatever I want. It just, well, help us build an industry that is trustworthy, that is sustainable, that is transparent, and that is considered as a useful tool. It's not an obligation, but it is an option that is available for consumers associations, for businesses, if they want to. And let competition play its role, I would say. Well, Malcolm, Danny, and Giacomo, many thanks for having shared your thoughts and ideas and experience with us. I hope it was interesting for all of you. It's only the start of the discussion because we now have lunch, so if you want to talk to any member of the panel directly, I guess you are available for discussion. Thank you very much. Thank you.
That was very interesting.